Hello, my name is Cathy Tracey, and I'm here to spend 5 minutes with you today talking about schools' rights and obligations around having service animals on school property. The right to have service animals derives largely from Title II of the Americans with Disabilities Act, which specifically allows persons with disabilities to bring, quote, service animals to all areas where the disabled person is otherwise allowed to go. Michigan has a similar law that applies to public accommodations, including private schools. Under federal law, a service animal needs to be fully trained, but in a few months, the Michigan law will also allow service animals in training to be in places of public accommodation. So what is a service animal? A service animal is a dog or a miniature horse that is individually trained to do work or perform tasks that are directly related to and mitigate a person's disability, including physical, sensory, psychiatric, intellectual, or other mental disabilities. So examples of this might include an animal that's trained to assist a blind person with navigation, or an animal that's trained to detect when a person with epilepsy is about to have a seizure so that it can help them to a safe place. Those would be examples of service animals. Often when people use the term service animal, what they're actually talking about are emotional support animals. Emotional support animals are animals that provide comfort or companionship, and their presence may even help calm a person with a mental disability. However, they have not been trained to perform any specific service. So for instance, a person having a panic attack who is soothed by being able to snuggle their dog, that would be an emotional support animal because it's the dog's presence that provides the support. On the other hand, if a dog were specifically trained to assist a person having a mental health crisis, like by interrupting self-mutilation or removing a disoriented person to a safe place, those would be actions of a service animal. The reason why this matters is that the very broad and specific protections for, quote, service animals don't apply to emotional support animals. There may, however, be some other laws that would provide some level of protection for emotional support animals. So for instance, if you have students who are covered by Section 504 or the IDEA, I would still recommend that the team at least consider whether the emotional support animal is necessary for the child to have faith. Also, for employees who are entitled to reasonable accommodations under the ADA and Michigan law, school employers should still work through the interactive process to determine whether an emotional support animal is a reasonable accommodation. So how are school administrators supposed to know whether an animal is a service animal or not? There are two and only two questions that you may ask. One is the animal required because of a disability? The second is, what work or task has the animal been trained to perform? Schools often get sideways with the ADA by asking disabled persons to provide documentation or some other proof that the animal has been certified, licensed, or trained as a service animal. That is not allowed. Schools can also get sideways with the ADA if they create policies and procedures around approval of service animals that go beyond those two permissible questions. So, for instance, OCR found that a school violated the ADA when, before approving a service dog, it required the student to provide proof of training, a current health certificate, and evidence that the dog was clean and well groomed. Assuming we have a bona fide service dog, who's going to be responsible for it? Generally speaking, the school is not responsible for the care of a service animal. The caveat, however, is that a school may still need to assist with care as part of its duty to accommodate the student's disability. Just like a school employee might provide some assistance to a diabetic student who's using a glucose monitor, you would have to provide the same level of support to a student in those cases. There are limited circumstances in which a service animal may be removed. One of them is if the animal is, quote, out of control and the handler doesn't take effective action to control it. So if a dog barks and doesn't stop when directed, that could be a basis for removal if it happens repeatedly. If a dog is jumping on others or aggressive or otherwise bothersome, that could be a basis for removal if the handler isn't able to effectively control it. As a complete aside, this is a picture of my dog, Maisie. Any of my clients who've spoken to me when I'm at home know that she is not a service animal because she barks constantly, and I have no ability to stop it. Another basis for removal is if the animal is not housebroken. And the final basis for removal is if the animal poses a direct threat to the health or safety of others. Keep in mind here that this is a very, very high standard. I've seen it applied where a service dog bit a child in the classroom, but in very few other cases. You may be wondering whether you can remove a service animal on the basis that they are a direct threat to students with severe allergies or students who fear dogs. The answer to that is no, you cannot. The school is expected to find a way to reasonably accommodate both parties in a manner that doesn't isolate or treat the person with a service animal less favorably. This might include putting them in different classrooms or different areas of the classroom or the building. So with that, my 5 minutes are up. Thank you for joining me. And if you have any questions about service animals, please feel free to reach out to your favorite Miller Johnson lawyer.